time. And what appears to be an action by Jimmy Kimmel to play into that narrative that this was somehow a MAGA or Republican motivated person. If that's what happened here with his conduct, that is really, really sick. And I've been very clear. They have a license granted by us at the FCC, and that comes with it an obligation to operate in the public interest. And we can get into some ways that we've been trying to reinvigorate the public interest and some changes that we've seen. But frankly, when you see stuff like this, I mean, look, we can do this the easy way or the hard way. These companies can find ways to change conduct, to take action, frankly, on Kimmel, or there's going to be additional work for the FCC ahead. We have a rule on the book that interprets a public interest standard that says news distortion is something that is prohibited.
Let's talk about this. As always, I want to note that I am not a lawyer and I don't have a law degree. The following are just my opinions informed by research and historical First Amendment case law. I want to share a few cases related to free speech and governmental pressure, but please form your own conclusions. This is just my analysis. First up, Bantam Books versus Sullivan. Rhode Island created the Commission to encourage morality in youth. On paper, its goal is to protect children from what it considered immoral material, certain novels and magazines. In practice, the commission sent letters to book distributors labeling specific titles as objectionable and warning that state police would be monitoring compliance. The commission didn't have legal authority to ban books, but the letters were persuasive enough that distributors removed the flagged titles. The Supreme Court ruled this unconstitutional, reasoning that even informal pressure or implied threats that chill speech can violate the First Amendment. The government doesn't need a law to silence people. A pattern of pressure can be enough. Fast forward to Hammerhead versus Brezhnev. New York City's official disliked a board game called Public Assistance, which satirized the welfare system. He sent letters to stores encouraging them not to sell the game. The game makers sued, claiming censorship. The court ruled against them. Unlike Bantam, there were no threats of punishment or implied enforcement. The official expressed disapproval, and stores could choose how to respond. This case shows that government criticism or advice alone is legal. It's only when there is coercion or threats that constitutional issues arise. In Penthouse versus Meese, Attorney General Edwin Meese led a federal commission on pornography that published reports criticizing magazines like Penthouse and Hustler. Publishers claimed this was censorship. The courts disagreed. No laws were passed, no enforcement occurred, and no direct pressure was applied. The ruling confirms that government criticism, even if strongly worded, does not violate free speech. The distinction from Bantam is clear. It's threats or coercion, not criticism, that can constitute unconstitutional censorship. Recently, FCC Chairman Brendan Carr made headlines over Jimmy Kimmel. Carr warned ABC affiliates that they could act against Kimmel, the easy way or the hard way, implying potential regulatory consequences if they didn't. He also suggested that broadcasting false information could technically violate FCC rules, even though such rules have not been enforced in decades. Legally, for the FCC to take action, that speech would need to cause actual or imminent harm to public health, safety, or property, which Kimmel's remarks did not. This situation reflects the principles in Bantam Books versus Sullivan. Even without a law, a government statement intended to influence behavior through implied consequences can raise First Amendment concerns. Criticism alone is permissible, but statements structured as "do this or else," even if unenforceable, can be considered pressure on speech. For Carr's statements not to qualify as threats, he would have to believe that he could enforce them legally. Since Kimmel's remarks did not meet the clear and present danger standard, any actual enforcement would likely fail, making the statement a suggestion of potential government action aimed at influencing behavior. Hammerhead versus Brezhnev showed that government can express disapproval or recommended action. Pantel versus Meese shows that strong public criticism is also permissible, but Bantam versus Sullivan establishes that the government cannot use implied threats to compel a specific action. Looming government pressure over a private media company, even without enforceable legal action, constitutes coercion under this framework. Therefore, Carr's statements align with a scenario that Bantam identifies as raising constitutional concerns. Similarly, any statements by presidents threatening legal consequences for media coverage would raise the same type of constitutional questions. Criticism is allowed, threats are not. If you like today's video, like, share, and subscribe so I can continue making content like this. Comment below with your thoughts on whether Carr's statements raise First Amendment concerns. And I will see you next time. Thanks.